Hi guys, and welcome to part 4 of the law on extinguishment of obligations. Specifically, we will be talking about condemnation or remission. Okay? So if you've been enjoying my videos and you want to see more, please hit the subscribe button. Okay? Now, a reminder for my regular viewers, this series is meant to be for educational or informative purposes only and is not a substitute for proper legal advice. For my students, please remember that this is not a substitute for actually studying and understanding the law. Okay? Now let's define what condemnation or remission is. It is a gratuitous abandonment by the creditor of his right against the debtor. Okay? So, I said it's a gratuitous abandonment. So, a condemnation or remission necessarily takes on the form of donations and is subject to the rules thereon. Okay? So, what are the requisites in order for there to be a valid condemnation or remission? First of all, it must be gratuitous. Okay? In other words, it's not subject to a burden like payment of money or any other burden. Second, there must be acceptance by the debtor since condemnation or remission is in fact a donation. Okay? Third, both parties, the creditor and the debtor, must have capacity to contract. Fourth, the condemnation or remission must not be inofficious. Now let's pause for a while and talk about what this inofficious means. Okay? This word inofficious. It simply means that a person cannot give away by donation or condonation or remission what he cannot give away under a will. Okay? If you've watched my previous video, you will know that a person can only give away by will the free portion of his estate. And how do we arrive at that free portion? By first satisfying the legitimes of the compulsory heirs. To find out more about the legitimes and the related concepts, please take a look at my video on the law on succession, specifically what do you leave behind or gain from a will. Okay? Now, let's move on to the final requisite for condonation or remission to be valid, and it's that in case the condonation or remission is done expressly, then it must comply with the form of donations. And what is the form of donations? In case if it is a movable property and the donation is done orally, there must be simultaneous delivery of the thing or the document evidencing ownership over the thing. Now, if in case the movable exceeds, if the value of the movable exceeds 5,000 pesos, then the donation and the acceptance must be in writing. Okay? Now, what if the thing donated is immovable? Then it must be in a public document. Okay? We just briefly passed upon those rules in donation, which can be a proper subject of a different video. Now, let's move on to the presumptions established by law when it comes to condonation or remission. First, we have what is called an implied remission. Earlier, I said that there was a form of condonation or remission that is expressed. Now, let's move on to the implied remission. Okay? There can be implied remission when there is voluntary delivery of a private document evidencing a credit by the creditor to the debtor. Okay? Why? Because if that private document evidencing the credit is in the hands of the debtor, we can safely presume that the creditor no longer intends to enforce that document. Because in order for the creditor to enforce the document, he must still have it and show it to court as evidence. Okay? Second presumption, if a private document evidencing the credit is in the possession of a debtor, then it is presumed that the delivery by the creditor to the debtor was done voluntarily in case the debt is not yet paid. Okay? But if the debt is paid, the presumption is different. The presumption in that case will be that payment was made. But for our purposes, in case the debt has not yet been paid, if the debtor has possession of the private document evidencing the credit, then the presumption is the creditor delivered it voluntarily. Next, we first discuss the principle that the accessory follows the principal. Okay? If you remember, we have different kinds of contracts, no? The principal contracts and the accessory contracts. Okay? An accessory contract cannot survive without a principal contract. An example of a principal contract would be the contract of sale. Okay? And an accessory contract would be probably a contract of guarantee or chattel mortgage in case of personal property. Okay? So now, what is the rule? In case the creditor renounces the principal obligation, he likewise is presumed to have renounced the accessory obligations, following the rule that the accessory follows the principal. But take note that the converse is not correct. Okay? The principal does not follow the accessory. In other words, if it is the accessory obligations that the creditor has renounced, the principal obligation or contract will still subsist. Okay? Okay. Finally, the last point that I want to discuss here is in case of a contract of pledge. A contract of pledge, which I will be discussing in a different video, is a security contract, no? A contract of security whereby which involves personal property, no? So the accessory obligation of pledge is likewise remitted, no? Or condoned if in case after the thing subject of pledge has been delivered to the creditor, it is suddenly found again in the possession of the debtor or of a third person who actually owns it. Okay? So that is the presumption. So that's it for condemnation and remission. Please look out for my next video on compensation. Thank you.